Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at an important book which has come to us from Sweet Maxwell. It's Sweet Maxwell's contract law library publications we're looking at today. This one is on a particularly interesting area of illegality and public policy. We're really looking at vitiating factors within the law of contract itself. This book has been written by Professor R A Buckley, and it's now in a fourth edition. Elizabeth and I excuse me, have given the review title for our book, review the following: an intriguing and scholarly perspective on the law of contract. Now that's what you're going to get, because the fundamental publication on the law of contract, which is the main work, is Chitty on Contracts, which has been around for a very long time now. But this book is dealing specifically with one area. Of course, Sweet and Maxwell's Common Law Library publishes Chitty and all of the other very substantial works on common law. But this particular book I found very helpful. It's not the easiest book to read in some ways, but it's a very important area. It's an area which has always been of interest, I've found, for those I've taught, because I've taught contract law, and I find illegality and public policy very interesting areas to talk to students about, because the question really is, why have people like judges decided that some things are illegal, that some things contravene public policy, and so forth? And we have some quite entertaining cases, which I'm sure, without mentioning names, many students will remember, some of which are quite funny and also, of course, daring. Now, what do we say about the book? Well, a number of things. We'll have a look at the book first of all. Here it is. It's got a nice little ribbon divider, which is very helpful because it's in green, this book. I'm just going to put it in the middle. There's the front cover there. You can see the spine. Now, there's nothing on the back. It's the contract law library itself. It's not a heavy book. Fourth edition, runs to something approaching 350 odd pages. Now we can see again the structure, very much the house style of Sweet and Maxwell. It's got paragraph numbering in the index. So again, the index is quite detailed. It's quite helpful, and it says legal taxonomy is the little heading at the top. So it's very much, as I say, the house style for Sweet and Maxwell for the index. If we go to the front of the book, you can see again, there is the main front page of the book itself. And then after that, we've got basic information and then a dedication, which I shall leave you to read there. Then after that, there's a preface to the first edition, which came out in 2002. And Buckley was very keen to set the record straight as to why he wanted to write it. He'd been, like I have, and I think many others, fascinated with the subject when he was a student, and the subject grew for him. This is the preface now to the current edition, the fourth edition, where he's indicated some changes which have come in, and I'm going to mention a few of the changes that have taken place. And his preface was written in February 2017, and I'm reviewing this after the general election of June 2017 in the summer. There's the table of contents, which you can see there, the various parts that he's split the book up into. Now obviously many students will know about restraint of trade. What you've got in part 6 are cases and comments, which are again I think very helpful. Probably explaining to one or two students and practitioners why these decisions have been arrived at. Then you've got the table of cases. Sometimes it's difficult to understand why judges have made decisions in the way they have. However, you have to think of the time in which the case has been decided. Table of statutes there, all the usual suspects, some statutory instruments, actually very little. Some European stuff, still with us and will be for a while with Brexit. Then human rights cases. They're called human rights cases, but it's the European Court of Human Rights we're talking about there. Then treaties and conventions. And then we get into the subject matter. General introduction, paragraph numbering at the sides, and then the footnoting there, you can see at the bottom, then it just runs through. As I say, one of the points about this book is that you've got to have, reading this book, you've got to have some knowledge of the subject matter. I didn't find it the easiest book in the world to read, but there again, sometimes the subject matter, when a contract is determined to be an illegal contract or contrary to public policy, you have to think carefully about the rationale behind the decision. And frankly, putting it in its bluntest form, when it comes to public policy, it is very much the morality of the time and the view of the establishment which comes into play. And that is bound to be the case. The only question is that I always bear in mind the basic content of a judgment, and that is that you have the decision by, let's say, 2 or 3 judges, but the dissenting judgment of today could well be the good law of tomorrow. So just bear that in mind when we're thinking about how these decisions are arrived at. So this intriguing and scholarly perspective, how does it come out in this book? Well, this is what we say. As contract law is the core of the law, as you might say, lawyers practising in a wide range of specialist areas, particularly corporate law, will, we think, be interested in this new 4th edition of Illegality and Public Policy, which comes to us from Sweet Maxwell and, of course, Thomson Reuters, and is part of their highly regarded contract law library of publications. It may or may not, of course, answer the question of when and under what circumstances a contract becomes unenforceable. If you go back to your very basic training, if you like, in the law of contract, you remember the different types of contract: valid, void, voidable and unenforceable. These are unenforceable because on prima facie, on the face of it, they look to be valid contracts. But for some reason, something has happened, a vitiating factor, that throws that out of the window. And that's really where we are with these types of contract. Clearly, an unenforceable contract is generally one that's illegal. But when matters of public policy enter the fray, look out for the complexities and confusion that may result, in which case this long-established legal text offers the scholarship, the authority and the depth of analysis you'll obviously need to add clout to your case. And I think you'll get it with Professor Buckley's statements, because at the end of the day, I've often found it the case as a practitioner that you don't sometimes know how the case is going to go, and you cannot for the life of you fathom how a judge has arrived at a particular conclusion. And afterwards it sometimes becomes apparent, but I have to say not always, especially on appeal. But there we are, that's what it's all about. Now, long considered this book as one of the more the subject matter, one of the more esoteric areas of the law of contract, the subject of whether a contract is illegal or contrary to public policy, and the issues which are involved are now coming under increasingly frequent scrutiny. And public policy in particular has a way of chopping and changing depending on what century or decade or year or week you happen to be living in, or who's in government. And I've recorded this after the general election of the 8th of June 2017, where we have a hung parliament. So at the moment we're in a really difficult dilemma with Brexit and everything else. And so many things are put to one side. So I do not expect any great movement in terms of changes in attitude on public policy, notwithstanding the fact that that could happen with a change of government in the future. For instance, classic examples are the areas where public policy does intervene, and we've given examples in our review here, from slavery and universal suffrage to the prohibition of substances, from alcohol to a whole pharmacopoeia of drugs, not to mention public policy on gambling. One can think of any number of examples where the shadow, if you like, of public policy is there. And I mean, classic example would be the Liberal Democratic view in their manifesto of legalising cannabis, which is currently a criminal offence to possess it illegally. And of course, again, we're looking at that as an attitude not just of criminality and illegality, but also, of course, of public policy, which could change dramatically if certain things happen. They're not likely to, but there again, there are a lot of reasons why things might not likely happen, but then they do. So you never quite know with these matters. the changing views of the times. For instance, I'm recording this on the 50th anniversary of the decriminalisation of homosexuality, which was, again, this is a classic example of a view in terms of public policy and criminality, which has completely changed since 1967. So you can see the views. Now, since the previous edition of this book was published in 2013, new developments have emerged in this area of law, and the most significant is the case of Patel and Mirza, which many of you will know, of course, which is cited any number of times throughout the text. It's dominating the discussion throughout, and this case in particular, in the author's words, clarifies the law on illegality, emphasising that it's predominantly a matter of substantive rather than procedural law. And I can see the basic concept in the history of the common law maintaining that particular approach as to why the subject matter, when something is classified as illegal, why it will maintain that stance. But as I've indicated, over the centuries and over the decades, things change. Basically, Patel and Mirza is cited as a watershed, so to speak, in mitigating the harshness which in the past has often characterised this branch of the law. Again, that's a point I think that comes out by changing attitudes to public policy. The court of public opinion, as Harriet Harman put it once, but I mean it's the same, basically the same point that's being put across, and as people's views change. It's affected, therefore, this case, a radical transformation in favour of flexibility and transparency, which in itself is part of a process towards much needed reform. And I'm sure that is right, because as I've indicated earlier, what is acceptable at one particular point in time then becomes unacceptable, and other things which have been acceptable, like certain use of certain drugs in the 19th century, becomes illegal. So you see the way in which things change. Now, the book's divided into 6 parts, each presenting a lucid and closely argued examination of the various aspects of what is a difficult subject for many. Practitioners faced with the problems that emerge menacingly whenever the public policy dimension raises its head will certainly appreciate the 6th and final part of the book, which provides hypothetical but plausible examples of illegality in typical situations and suggests ways in which such difficulties might be solved. For the beleaguered practitioner, then, this section is pretty handy, and I do advise you to have a look at it. We'll have a look at it at the end of this review. This is my final sort of comment, if you like. It's important to note the resources that researchers and practitioners find so useful, namely tables of cases, statutes, SIs, European cases, treaties and conventions, and the European Court of Human Rights cases are all here. It's extensively footnoted, and the book, I think, is pretty easy to navigate, with a detailed table of contents at the beginning and a lengthy index, so you should find what you're looking for without too much difficulty. In the confusing times we live in, illegality in public policy should ideally be ensconced in every lawyer's library. I'm sure it probably will be, because it's an important statement of this particular area of contract law. The date of the publication is cited at 2017. Let's just have a quick look at it again. There's the front. Just looking at the comments which Professor Buckley has made. Preface to the 4th edition, there it is there. He talks about Patel and Mirza in quite a lot of detail, and some of the other case law that is mentioned, dealing with third-party funders and so forth, is also covered there in some detail. And as I mentioned right at the back, you've got quite an interesting series of comments. If I can just find them here. These are the hypothetical situations involving illegality. Now this is round about page 340. There are a whole list of them. There are, I don't know how many, there's certainly 10. It starts off illegality in performance and then runs all the way through. So what you've got is the purpose of the chapter is to outline numbers of possible situations. Now this may be of help to you as a practitioner. I don't say necessarily will, but it might give you some bearing depending on what sort of problem is coming your way for advice by way of an opinion or whatever it may be, or even advice in conference to a client, depending on what facts you've got before you. it's like many of the stuff, bits and pieces we have today, quite often we end up with very little paperwork at the beginning, and so it may be that you need to refer to this when you're looking at the case in the round. I'd like to thank Buckley and all the other people involved very much indeed for producing this work. It's up to the highest standards of what we expect from Sweet and Maxwell. We can't do our work without the books that you kindly publish for us. This is where the common law is, this is where the law can be found, and you make our lives a lot easier. So a big thank you to everybody concerned, and thank you again for publishing the new edition. Bye-bye.